What do you mean by contract?
Meaning. The term contract is derived from the Latin contractum, which means drawing together. It is an agreement to do or not to do an act. It comes into existence from the action of the parties. It creates legal rights and obligations. It is enforceable by law. Some of authors' and jurists' definitions of the contract are: 1. Salmond. Salmond defines a contract as an agreement creating and defining obligations between the parties. 2. Sir William Anson, a legally binding agreement between two or more persons by which rights are acquired by one or more to act or forbearance on the part of the other or others. Blackstone, he defines a contract as an agreement upon a sufficient consideration to do or not to do a particular thing. Sir Fed Pollock, every agreement and promise enforceable by law. Section 2(h) of the Indian Contract Act defines a contract as an enforceable by law. From the above-mentioned definitions, it is quite clear that every contract is a legally binding agreement. It consists of two essential elements, namely, obligation and agreement. An obligation is a legal tie which binds the parties together. It is an undertaking to do or to abstain from doing some definite act. It may relate to either social or legal matters. Social obligations are not enforceable. Legal obligations, which have their source in agreements alone, are enforceable. Thus, every contract is an obligation, but all obligations may not be contracts. According to Anson, a contract is that form of agreement which directly contemplates and creates an obligation. Thus, all contracts are agreements, but all agreements are not contracts.